Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio every Saturday at 3 p.m. Today is July 27, 2024. The music you heard was by a woman by the name of Lucy Thomas. And the song, of course, was Hallelujah. I always loved that song. So I figured I'd give it a play today. Today, the opening topic is going to be about accessing a tenant's unit. What are the reasons that you can go into a tenant's unit? What forms are required? What are the steps required in that situation? So I have a form on my website, which is, of course, evict123.com. And if you go to that free form section, you will see the notice to access the dwelling. And you just can't, have a whim that one day, gee, you know what? I think I want to go in to the tenant's unit. I want to see what's going on in there. That's not permitted under the code. The code is Civil Code Section 1954. I do want to share my screen right now to show you what that form looks like. Let's take a look here. Okay, so she should be able to see that form right now. The form is entitled 24-hour notice to enter the dwelling. What that means, number one, is that you have to serve this notice at least 24 hours in advance. Serving the notice means either handing it to the tenant or posting it on his door or her door. And you have to pick a date that is normal business hours, Monday through Friday, 9 to 5. That would be the normal business hours that you can access the unit. Now, you certainly do not need this form if you've got water cascading from the unit. If it's an emergency situation, then please just go on in, call the police, call the fire department, use your key. If you see smoke coming out of the unit or there's water coming out from under the door, that's an emergency situation. Obviously, we're not going to serve a 24-hour notice. But if it is not an emergency situation, then you have to have specific reasons. So let's go down to the specific reasons here. The major ones are to make necessary or agreed repairs. So maybe you've gotten a notation or a citation from the building and safety that something needs to be done, or maybe the tenant has told you, hey, it appears that I've got rats in my unit. Well, then that would be one reason that you could use. Another one, if you had to make an alteration that was required or an improvement that was required. Pretend the carpeting was worn out and it's creating a dangerous condition, so you would need to make an improvement. With regard to other issues, if you're going to show it to a prospective or actual mortgagee, what that is, like if you're going to refinance your property and they got to get an appraiser in there, that's what that represents. Or, for example, if your tenant has told you that they're moving and you want to try to rent the premises out prior to your tenant vacating, then you could check number 5 there, which is to exhibit the dwelling to prospective tenants. Number 6 right here is dealing with if you're going to sell your property, you have the right to show it to agents, your real estate agents, or you can show it to prospective purchasers. That would be number 6. Number 7 would be if you have to do work in the unit, then you've got to be able to show it to a contractor or a workman. So that's required. Again, pursuant to a court order, that's where you're getting a citation from building and safety or some municipality telling you that, hey, you've got to change the windows because they're decaying and they need to be changed. So that would be pursuant to a court order. And the last one, which we use a lot, is this one here, number 9. And that is to determine that the premises have been abandoned. Sometimes you have a tenant, he hasn't paid rent for a while, at least 14 days, and you have a suspicion that he moved out in the middle of the night, as a lot of tenants do. Well, if you have a reasonable suspicion that he's abandoned the premises, you want to go in there and take a look. So you would check that last box. And then 24 hours later, you go in with a key and you see what you see in there. If everything is out of the unit, it's completely bare. Well, guess what? The tenant has abandoned the unit. So that's one way to determine whether there's been an abandonment or not. So let's go back up to the top of the form here. If you were going to fill this form out, you would put in, of course, the tenant's name. Then you, of course, would put in the address of your property where the tenant is staying. As I fill it out here. I think my typing this week is much better than last. Now, this is the date that you're going to go in. So let's call it August 1st. And this is the time. So you're going to say from 9 a.m. to, let's say, 12 p.m. Then, of course, you would check the proper box. And then, of course, you'd put today's date, the date that you're preparing it. Oops. You would type in your name here. You don't have to sign it. And then you have to tell them exactly what work you're going to do. Like I am going to, in this case, I'm going to fix the leak that's in the bathroom. So once this form is completed, and again, you can fill this out right on my screen, then you're going to print it out and you're either going to hand it to the tenant or post it on the door. Can you mail it? You have to allow additional time if you mail it, so it's not generally a practical way to do it. So fill this form out and send it in. Okay, now let's say what happens when you, here, let me get rid of this right here. Leave. And what we're going to do now is we're going to talk about guidelines. And I presume you guys are seeing the guidelines for accessing a unit. So you serve this notice, and in a lot of situations, the tenants are trying to create a situation where they'll complain something is wrong. Maybe they don't even tell you, they tell building and safety or the housing department. You get this order to comply, and you're thinking to yourself, well, why didn't that dummy tell me directly? Why did he have to go to the city? Well, the guy's not a dummy. What the truth is, he's trying to build up a case for himself so he can withhold rent by not telling you, telling the city so it looks like you're a bad landlord. So, and this is just a common practice that tenants do. So as soon as you serve that notice, what's going to happen is that, here, let me make this a little bigger. Your tenant is going to call you up and say, I'm sorry, I can't make it that day. So pick another date. Well, if you're picking a date between Monday to Friday, 9 to 5, the first thing is it doesn't matter what your tenant says. You're not going to listen to them. So regardless of the tenant's response, arrive at the unit at the appropriate time. The tenant does not have to be there. So when the tenant tells you, well, I have to be there. Well, no, you don't have to be there. This is the time I'm picking. This is what the code allows me to do, Civil Code Section 1954. And I'm going to show up at this time because this is a necessary repair that I have to make. Now, you arrive at the property, regardless of what the tenant told you, like I'm not letting you in or I'm not going to be there, so don't go in. You do arrive at the property. The next thing you do is you knock on the door to see if the tenant will allow you access. If he opens up the door and ushers you in, very good. Go on in there, do the work that you need to do and leave. But what if there's no one opening up the door for you? Well, in that case, it's perfectly legal to use your passkey to gain entrance to the property. Use your passkey, go on in, do the work that you need to do. And then if the tenant, then lock the door on your way out. You're not changing any locks, you're just using your own key. What if you determine that the tenant changed the locks? Well, number one, if the tenant changed the locks, as we learned from last week's show, you have the right to evict for an alteration of the premises. But in this situation, when you're desperately trying to get in, if you don't have a key or you never had a key, you have the right to engage the services of a locksmith, Once again, you're not going to change the locks. You're just going to use the services of a locksmith to open up the door, gain access to the unit, and then do the work that needs to be done and make sure the unit is locked on your way out. Now, what happens, ladies and gentlemen, if the tenant opens up the door, stands in the doorway and says, "I'm not letting you in"? Can you take your two hands and shove them back? And the answer is no, don't do that. That's silly. But what you can do is say, "Look, I have the right to go in. I've served you proper notice. If you don't let me in, this will be grounds for eviction." At that point in time, I would take out your cell phone. I would video him refusing to allow you to access the unit. In some instances where it's incredibly important for you to get in, there's a leak or something, you might want to call the police department and tell them that I'm asking you to come to keep the peace because we're going to have a big war here if you don't come and allow me access to this unit. Again, if the tenant refuses to let you in and you have no way of getting in, that would be grounds for eviction under most rent control statutes, certainly the ones in Los Angeles and unincorporated areas of LA County, and also under statewide rent control. So if the tenant doesn't let you in, then that would be grounds for eviction. And of course, you want to, if you're under some sort of a court or a building and safety order to comply, you might want to call the inspector and tell him what's going on and explain that, "Hey, my tenant is not letting me in, so you're going to need to give me more time. And by the way, I'm going to call Dennis Block to start an eviction." Anyway, ladies and gentlemen, that is my topic for today, accessing a unit. Again, that form is on my website. And if you, hopefully you can see me now. That form is on my website. So if you need that form, please use it, serve it in the manner that I've told you, and you should have no problem gaining access, or you're going to have a wonderful case for eviction. We're going to open it up today to a regular Jim Polona. I'm going to ask you to unmute yourself. Jim, are you there?
Hi, Dennis.
Hello.
Hi, Dennis. Oh, good topic. Very good. I have two questions. One, I'm a little confused on security deposits. If there's unpaid late fees, can I deduct that from the security deposit?
And the answer is, from a security deposit, you're allowed to deduct unpaid rent, reasonable cleaning charges, and unusual wear and tear. Notice I didn't say late charges. So unless you have a provision in your lease that says that all monetary obligations are considered rent, then you would not be able to deduct it.
Okay, so I do have that clause in my lease. Okay, thanks. Question two, going back to my friend who negotiated a cash for keys, I was really confused on the dollar amount. It was $27,000, and she was under statewide rent control. She was supposed to only receive 1 month's assistance, rental assistance.
Well, let me stop you here. Your friend is the tenant who received this
yes,
this agreement to vacate.
Yes.
Okay. Continue.
And I don't know why the landlady would agree to $27,000 when she only owed 1 month's rental assistance.
I think that's obvious, Jim. That landlord doesn't listen to my telecasts. Because obviously she had no obligation to do that. Why did she want the tenant to move?
Well, she was undercharging for 20 years. Then she gave the 90-day notice to double the rent. And that's where the conflict arose.
Well, the issue is this is an apartment. So if you're under statewide rent control,
it
was a
house.
home.
Yes.
Okay, so then she could have avoided that by just merely raising the rent to market level, because that's what the law allows any person, regardless of what jurisdiction, regardless of who the tenant is or who the landlord is, a corporation, you can raise the rent to market value. So the issue is that the landlord just kind of made a mistake, and your friends in a very good position that they got $27,000 because there was no necessity for the landlord to do so.
So I know that the landlord would have to, if the eviction went through, the landlord would have to pay attorney fees But I can't imagine attorney fees being more than 27,000 or even approaching 27,000.
Barely anything, certainly if you use my law firm. So,
Okay, thank you, Dennis.
all right, Jim, nice talking to you. Okay, and by the way, everybody, I have an announcement. I talked about it last week. I'm going to save it to the end of this show. So stay tuned to the end. Austin Rosinka, I'm going to ask you to unmute yourself
Hi, Dennis. Can you hear me all right?
perfectly.
Oh, great. So, following up on Civil Code 1954, you served your notice 24 hours, you're there, and then all of a sudden, a minor child opens the door and the parent is not home. I still want to get into the unit, but I see what the parent is trying to do. What's the best way to protect myself?
The best thing would be to call Child Protective Services because the minor's not be allowed to be left home at that point. So I would throw it right back at them. I think as a practical matter, I wouldn't walk in if it was just a child in there. You don't know what's going to happen. But if there's a child in there all by themselves, I think the parents have a major problem, and I would call Child Protective Services right then and there, have them go out and let's see what the story is. So it's really a silly plan on the part of the tenant to only have a tenant, the child come to the door.
Would you recommend just going straight to CPS or just calling the police to keep the peace and have them just monitor?
I'd probably do both. Have the police come. At that point, there's a child in a house by themselves. That doesn't sound safe. So I
Yeah.
think that's a good idea. Do both and call Child Protective Services.
Okay. One other real quick question. So I'm owner occupying a fourplex in the city of Long Beach, two single family homes and a duplex on the same lot. My quick question is, if I'm owner occupying one of these units and I'm renting a room in the unit that I'm occupying, is that roommate still covered by AB 1482?
The roommate, I think it still is covered by 1482, but it really comes under what they call a lodger situation. So if you're in the same unit and they share the kitchen and living room with you, then you don't need a reason to evict in that situation. So that
Okay.
portion of it is exempt from AB 1482.
Oh wow, that's critical. Okay, because I sent out a lease telling the tenant that they were subject to AB 1482, and it sounds like I can save myself a lot of pain just by doing a lodger agreement instead.
Right. And of course, you have to really be careful. I mean, I understand the economic concerns, but you really have to be careful when you have a stranger become your roommate. It's bad enough when you have your girlfriend move in, who you know, but it's really, I think it's a very, I mean, unless the economics just are requiring you to do so, if you can avoid having someone live with you, I would probably recommend that.
Yeah. Okay. Thanks, Dennis.
All right, Mr. Austin, thank you. Okay, so we're going to move on to Sam. Hello, Sam. Say hello by unmuting.
Hi, how are you doing, Dennis?
Sam, I'm good.
Okay, question. Just something you may have dealt with on Inside Edition, but I never caught the clip. Suppose a buyer of a residential condominium unit or a single family residence enters into an agreement to buy the property, and the seller is in possession, and the seller says, "Oh, don't worry, we're gonna move. We're gonna move." At the end, and say that the agreement specifies close of escrow plus 3 days, for example. The seller doesn't actually move. Is this a problem, and how do you get the seller slash tenant out? And how difficult is that going to be? And what it just have is it going to be through an unlawful detainer?
Okay, well, first of all, we're confronted with this situation every day.
Mhm.
People might know that I write a column for the Apartment Owners Association magazine. And I just wrote about this question today, which will appear in the September issue of the Apartment Owners Association. The obviously, when escrow closes or pursuant to the terms of the escrow, the seller of the property has to vacate. Before I get into the answering your question, if you're going to have the seller remain after the escrow closes, whatever you do, don't get into what they call a lease back, where you're leasing the property to the previous owner for, let's say, another month or two. I need a month to get out, and I'm willing to sign a contract and that I'll pay for another month's worth of rent. Don't ever do that. Just have it where it states that even though escrow is closing, that the previous owner will vacate in 30 days. And then what you can do, you can have an adjustment in escrow for 30 days worth of quote rent, but we're not calling it rent, where the price will be lessened due to the fact that he's not giving up possession. As soon as you call it rent, he becomes a tenant. And if he's a tenant, he's got all these damn rights, whether we like it or not. Now, but let's pretend you just said in your escrow agreement that the owner to vacate 3 days after the close of escrow. In that situation, if he's still there, the new owner has the right to serve a 3-day notice to quit. If the occupant doesn't vacate at the end of the 3rd day, you have the right to bring a type of unlawful detainer, a type of an eviction case. In our office, we call it a sale eviction, where you sell the property and then you don't move. We see these also where the previous owner, the seller, did move, but he left his son behind. And that would be the same situation where, hey, I moved. I can't deal with my son. He's refusing to move. So I guess it's your problem, Mr. Landlord. So now at that point, we'd serve a 3-day notice on the son and then start an eviction lawsuit at the end of the 3rd day.
Is it called a detainer? Detainer with a D or
No,
something?
it's an unlawful detainer, 2 words.
Yeah. Okay. Very good. Thank you, Dennis.
Okay, thank you, Sam. Okay, so we're going to move on to Edith. Edith has an iPad. Say hello, Edith.
Hi.
Hey there.
On owner occupancy in LA City, when they say it has to be your primary residence, does that mean you need to file the IRS with your primary residence as the apartment, as opposed to your single family home? Or do they just mean
what
okay.
IRS would have nothing to do with this. I'm not sure what the rules are for the IRS that you list an address that is your primary address on your IRS returns. I don't think you need to. I think you could list any address. So I don't think the two are tied together.
Okay, so they just want to make sure that you're living there, the utilities are in your name.
Yeah, no, you really have to live there. Somebody's gonna come back and check.
Yeah, that's the
So
plan.
you have to establish residency there. Correct.
Okay, that's the plan. The concerns mostly for the IRS. I can ask my other question next week.
No, actually ask it now because I see we don't have as many hands. So go ahead
okay.
if you have it.
Well, also, it's relevant to your discussion earlier about notices to enter and what happens if the tenant refuses. So we did serve proper notice, but the situation with this particular tenant is contentious for various reasons. So it's my parents' building. They only have one. It's 5 units, and I help them, and they're seniors. My involvement is just more. So this gentleman has a problem with me, and he called the city. So the city said we needed to do this work. We posted the notice and said that it's to do the repairs for this inspection. He came out and said, no, I don't need the whole family, which is just my mother, who's the official owner, and then she named me the manager. Can he, one, do that, restrict it because he says, oh, there's too many and you guys are harassing me?
Well, how many people are going in? Just you and your mother? And also
Yes.
workmen? What about the workmen?
Yeah, and a workman. Yeah.
That's a close call. So I don't know what the court would do with that. Would that be grounds enough to evict because they didn't let all 3 people in? I think without throwing caution to the wind, I would say just have the owner or the owner's agent and the workman come into the unit. I think that's reasonable.
Not owner and agent. Because
No,
I would
not
be the
owner
agent.
and agent, no.
Okay. And then if he starts recording me and says, I'm not letting you in unless I record, and I don't want to be recorded, then what do I call the inspector and say he's doing this to provoke me, or
I wouldn't worry about that.
let him record me?
Let him record you. What do you care? You're doing what you're
Okay.
supposed to do. And in fact, if you want, you can say, if you want to record me, I'll record you.
Okay.
I'm just kidding, but I mean, it's silly. You're just walking in
Don't give
there,
them more than what, yeah, don't
just
feed
get your
into
hair
them.
done before you walk in there. That's all.
Okay, thank you so much.
All right, bye-bye. I see somebody who calls themselves a Zoom user. You're a new person. Please unmute yourself.
Hi there. Is it me?
Hey there. What's your
Okay.
first name?
It's Randy.
Hello, Randy. How are you?
Hey, Dennis.
Are you new to our channel?
I've been watching, but I haven't called in this way or asked a question
Oh my
anytime.
God, you had the courage and the strength to do it today.
I did. And I have two questions. I own a single family home that I inherited in Pasadena, California. And I ultimately I want to move back in, but with the new rules, I'm concerned that like I'll have to pay all of the relocation fees and stuff. And to be quite honest, I'm not in a place to pay for it. We've been paying them, I mean, charging way under market rate for the home, and they've been there for a while. So
Well,
at,
let me give you the answer to your problem, and it's not necessarily in the way that you're looking at it. If
sure.
your property is way under market and this is a single family residence with only one house on the lot,
Yes.
raise the rent. There's no limitation. Don't talk to me about Pasadena and their rent control. You have the right to raise it to market level. If you're not sure what market level is, go to a website called, which I always hype. I wish I had
Yes.
stock in that, which is Rent-O-Meter, R-E-N-T, the letter O, meter.com. Put in it's the first 5 are free. Put in your address, how many bedrooms, what type of a property it is.
Yep.
And they'll find out what market level is very quickly. It's very accurate, in my opinion. And then serve a notice. You're obviously going to serve, it's going to be more than a 10% rent increase. So we know you're going to
Yes.
need to serve a 90-day notice at an additional 5 days for mailing. So as
Yes.
soon as this broadcast is over, then you're going to do up a 90-day notice. And it's going to be effective since we're in July, August, September, October. It's going to be effective November 1. Mail it out today and go to market level. And if they want to pay it, you know what? The worst that happens, you put the extra money in your pocket.
Fair. The only concern I have is that it sounds like in Pasadena, if they feel like they can't afford it, they can then go to the rent board and say they have an inability to pay. And then if I think they're just entitled to relocation at that point. So I'm
And
concerned about raising it.
there is no law like that. That law doesn't exist. There's something kind of a law in the city of Los Angeles. Pasadena doesn't have that law that I'm aware of. So the tenant just either has to pay or move.
Gotcha. Okay. Well, I think that was kind of my strategy, is raising the rent and hoping that they'll say this is too high and then move out. So maybe that'll work, maybe it doesn't. But I guess I'm worried I'll never
Any
be able
way
to
you
move
look
back
at
into my
it,
house.
yeah, but any way you look at it, everybody, listen to me. You must, if you have the ability to get your property to market value, do it. You don't know what's coming around the corner. You don't know what politicians are going to be doing. President Biden, on one of his, should I call it rants, said that we want to do a national uh, rent control, national rent control. I don't think he has the power to do it, limiting all rent increases to 5% on
Right.
residences. So you have an obligation to your children who will inherit this damn place to make sure that your rents are at market value.
Gotcha. Alrighty. Well, kind of answered my second question, but maybe I'll just ask it just in case. So when it comes to owner occupied move-ins in Pasadena, it sounds like you could potentially do a buyout agreement instead of the whole I want to move in and now you're entitled to relocation fees. Are you familiar with that process? And
Yeah, you
if I
can
do raise
do.
the rent now, and will they consider that retaliation if I both say I'm raising the rent and then later down the line say, and now I want to move in, kind of thing?
No, I mean, you have the right to raise the rent. Listen, if I can't move in, then I need extra money to live someplace else.
Yeah.
So I don't see that as an issue at all. You can do a voluntary vacate agreement anywhere, including in Pasadena.
Mm,
I'm not sure if they have any special rules with regard to that. I'd have to look that law up. But you can always, there is no specific amount since it's a voluntary. You could do it for $1,000, $100, or
yeah.
$100,000.
Okay. It wouldn't be considered retaliation for me to, I guess, raise the rent first before any
No,
kind of.
you're
Okay.
raising it to market level. What's wrong with that? Okay.
Okay.
That's all I'm doing is
Pasadena's
raising
has
it.
really interesting rules and they've really made it hard for owners right now. So I just want to
Well,
make sure I'm
yeah,
not.
nothing limits you from raising the rent to market value.
Thank
Anyway,
you so much for letting me ask a question. Thank you.
no problem. I'm glad you had the courage. And we're going to move on to Cassandra. Cassandra, how are you today?
Good afternoon. Can you hear me okay?
Perfectly.
All right. Hi there, Dennis. Couple questions, but I'll go one at a time. You can tell me if I need to stop. I have a 4+ unit building in East LA, which is unincorporated, and I have a separate parking agreement with the tenants. It shows a zero cost for the parking only because I inherited when I bought the property. There was no mention of the parking, uh, but the tenants, of course, they use the garage and they use the parking. So I thought I could start this way. Now I'm wondering at this time, can I increase, start charge them 30 or $50? Um,
Okay, let me get the facts straight. You
okay.
told me that in addition to the rental agreement for the unit, they all have a separate rental agreement for parking?
Yes.
But on that rental agreement for parking that's signed by the landlord and the tenant, it says that the rent for the parking is zero.
Uh, okay, so I use the AOA rental agreements. And so on that first page, I show no parking for the tenant, no parking space.
Correct.
Uh-huh. But I
But
have,
then you have a separate parking agreement.
yes.
And on that parking agreement, what does it say the rent is per month?
At this time, it says zero.
Okay, so I just want to get the facts straight.
Okay.
Since it's on a separate agreement for zero, you can do whatever you want. You can serve a 30-day notice that I'm taking away your parking spot. You can serve a 30-day notice that I'm increasing the rent on the parking spot from zero
Okay.
to whatever you want, $200, 250, whatever you want for it.
Okay. And I could do that in addition to increasing their rent.
On
Okay.
the residents, yes. You have two separate tenancies. One is a
Okay.
commercial tenancies that is wide open. You can charge whatever you like. You could
Perfect.
demand a security deposit on the parking space, the parking agreement, or you can just serve a 30-day notice. Hey, you know what? Get out. I don't want you parking here anymore.
Okay, perfect. Thank you. And then my second question is, can I start enforcing the renter's insurance? Because up to this point, I have not been enforcing it, but it is I use the AOA agreements. Can I say, hey, you need to obtain a renter's insurance policy?
You can certainly demand that they have a renter's insurance policy, but under cases that came down in the state of California, we can't serve a notice to perform or quit when the rental agreement clearly states you must have renter's insurance. But you can't bring forth an eviction because this particular court's decision, the appeals court decision, was that's considered too much of a trivial breach. However, the reason why you want to have that clause in your contract is because, and we just had this just the other day, a client of mine, in fact, I'm writing a letter to the legal aid attorney who made a demand of my client to pay $20,000 in for damage to the tenant's personal property. What had happened to the unit was that the unit was infested with mold, and my client didn't take care of it quick enough, even to their own agreement that they needed to act on it quicker. This is an institutional client with many units. So the tenant's attorney from legal aid sent me basically a laundry list, and they were really, it was really a good letter. It had receipts of all the personal property that was damaged as a result of this mold and that had to obviously be tossed. And they had receipt after receipt. I don't know how this woman did this, and it totaled up to $20,000. Well, while I can feel for the tenant, the rental agreement that my client has, which is also on my rental agreement on my website, and also the AOA rental agreement, states that the tenant has to maintain renter's insurance, that this renter's insurance should cover all personal property and any relocation expenses, assuming the tenant has to temporarily relocate. And it also goes on to say that the tenant waives any right to sue the landlord for any damage to personal property, even if it's the landlord's own negligence that created the damage. So if that's in your contract, you have at least a position that even though you can't force the tenant to maintain renter's insurance, if something happens to the unit, like a flood or something, the tenant can't look to you towards compensation.
Right. I'm almost wanting to enforce the renter's insurance, because say if they're cooking on the stove, that they cause a fire, or they overflow their bathtub and damages
Well,
the.
renter's insurance generally covers the renter.
Okay.
Not your insurance policy would cover any fire damage, etc. Your insurance company would have what they call the right of subrogation. They could go after the tenant if the tenant negligently created a fire. So your insurance covers that. Why you want your tenant to have renter's insurance is to prevent them from suing you. So if it's required that they have that and they don't, then you have the right to tell the tenant that I'm not going to be responsible for any of your personal properties, which is the letter that I addressed to my client's attorney just on Friday.
Got it. Okay. Okay. I think that makes sense. That'll be it for now. Thank you.
Thank you, Cassandra. Okay, we are moving on to Mr. Derek. How are you today?
Hey, good afternoon. Thanks, Dennis. Quick question on your topic. On the entry into the units or the single family house, can those notices ever be emailed, or would that not stand up at all?
You can do email if the contract provides for it. So if you like dealing with emails, you can say all notices can also be sent by emails and just put it into the contract. But if
But it
it's
has
not
to
in
be
the
in the contract.
contract, then you can't do that. It's not considered legal.
Okay, thanks. And then on to my two questions. LA City single family house. If there's a 90-day notice issued for an increase of rent over 10%, and that date has two conflicting dates on when that rent is supposed to begin, will the court go with the later of the two dates, or just invalidate that notice totally?
I probably have to see it, but my first intuition would be to state that it would be the longer of the two dates. See, in ours,
Okay.
we always write 90 days or this date, whichever is later in time. So we're going to serve a 90-day notice, or even if it's for 30 days, we'll say 30 days or this date, whichever is later in time. That's the language that should be used. But if you have something inconsistent in there, then I would think, and without looking at it, I think it would default to the one that was last in time.
And then to touch on your topic from a few weeks ago on that, if the new owner in providing that notice never previously provided the change of ownership documents upon changing of ownership, like a year prior, that would invalidate the notice down in court then, right?
What notice are you referring to?
The change of ownership, if they bought the property or they inherited the property from somebody else and they never provided the
But
tenant notice.
who are you saying the new owner who just purchased it didn't do a change of ownership?
The new owner acquired the property like 6 months prior due to inheritance and never provided notice of the change of
Okay,
ownership.
but there's no problem with that. As soon as the current owner realizes that he needs to send a change of ownership, you do it. The problem with that is if any rent was owed for previous months, you wouldn't be able to seek that in an unlawful detainer. You could sue for it in a civil action or small claims court, but you wouldn't be able to seek it in an unlawful detainer. But if the tenant's current in his rent, let's pretend you bought the property a year ago, you never informed the tenant in a specific writing in accordance with the law that, hey, I'm the new owner. You told them, but you didn't have all the language that's required in it. It makes no difference. The tenant's been paying rent. He knows where to pay rent. And now we're in the month of July. Now, if he doesn't pay July's rent, serve your change of notice of ownership and then serve a 3-day notice. In fact, you can serve them concurrently. So there really is no problem with that.
Okay, great. And last question. If the tenant provides the information that they've joined a tenant's rights group or something, should you wait 180 days or anything to avoid retaliation laws, or you just go ahead and take your actions right away and ignore that?
How are you retaliating? What are you doing in 180 days that you can't do now?
To avoid that being raised as a defense.
Right, but what you have to be doing something so that they say, oh, you're retaliating. What is the act that you're doing that the tenant might claim that you're retaliating?
Oh, raise the rent.
Okay, but if it's a lawful rent increase, I don't see that's going to be considered retaliation. Now, let's pretend you're in a single family home and he's exercising his rights and now you just jack up the rent above market, then I could see that could be considered retaliation. But other than that, if you're just if he wants to start a tenants union, God forbid, in your 8-unit building and everybody's joining the quote tenants union, but yet, hey, you know what? I'm allowed to raise my rent 4% if we're in the RSO properties for the city of Los Angeles. That would not be considered by the court to be considered retaliation.
Great. Okay, thanks for answering these questions.
You're very kind. Okay, let's move on to Patsy. Patsy and Grace, I think it says. Say hello. Patsy and Grace. There you go.
I'm here. Sorry, it took me a minute there. Thanks, Dennis. I appreciate what you do for all of us every Saturday. It's really above and beyond the call of duty. That's me, but thank you. I have a property in North Hollywood, which is obviously the city of Los Angeles, which is a problem. And I've had this property for 30 years and I'm really eager to get out. I have a tenant right now who barely lives in the apartment, the unit, and most of the time he lives in Texas. And I just found out recently that he has a buddy who is in the unit now and I didn't know anything about it until now. And evidently this has been going on since November. And so I talked to the tenant and I said, that's not something that he can do, just bring someone in. And we came to kind of an agreement that I would just give a rental agreement, have the other guy fill out a rental agreement. And if it was approved by me, that the guy could stay.
And what advantage of that is to you? You're way under market value on the property, correct?
Yes. Yes.
Okay,
no,
so
the only value to me is that I really want to get out of this. I want to sell the building.
But you can always sell the building, whether the rents are low or whether there's strangers living there or not. You can always sell a building. The issue is if you want to sell the building at a much higher price, you want to make sure that that unit is a market value. So how do you do that? Does your tenant who's now living in Texas say he's giving up the unit, but it's okay to rent it to this stranger?
No.
Okay. So on that basis, you don't want to do what you're doing. That's silly. What you want to do is you want to serve a 3-day notice to perform or quit, giving your tenant 3 days to get rid of this stranger. At the end of the 3rd day, we have the right to bring forth an illegal action, an unlawful detainer, to evict everyone from the unit. Once everyone is evicted, and we have the right to do so because your tenant's violating the terms of his rental agreement because he brought in a stranger in violation of the agreement. Once everybody is evicted, guess what? You get to raise the rent to market value.
Yeah.
And you know that how much more, if you can get another $1,000, do you know how much more you can get for the building?
No, how much?
It's astronomical, like $150,000 more just by getting one tenant out and raising the rent $1,000.
Wow, that's amazing.
Yeah,
Okay, so
I'd make a phone call to the office on
I was
Monday.
I was going to say, can I call and get this taken care of Monday?
Yes, just call the office. Okay.
Yeah. All
Don't give
right,
them
I
no
will.
rental agreement, my love.
Okay. All right. Thank you.
All right, you take care.
You too.
Okay, we're gonna ask Sal to unmute himself.
Hi, good afternoon, Dennis.
Hi.
Hi, so I currently have a judgment with a tenant I was evicting. So we had a settlement, and in the settlement, I agreed to seal the eviction unlawful detainer as long as they moved out on August 1st. And so if they don't move out August 1st, what do I have to do to make sure that's unsealed?
Okay, well, I would have to see the terms of the judgment that you entered into. I presume this would be a stipulated judgment where the parties agreed to this. And it would have to be the wording in the judgment. Most of the time, it requires that either you or your attorney file a motion with the court to have the record unsealed on the basis that the tenant did not comply with the terms of the stipulation.
Okay. And proof wise, how do I bring forward the proof that they stayed past that date?
Well, just your testimony. I saw them there. I went there on the day that they were supposed to be out, and look at this. They were there. I don't think there's going to be much argument on that.
Okay. Okay. Sounds good. Thank you.
Thank you, sir. Okay, we're moving on to Anthea Raymond. I'm going to ask you to unmute yourself.
Hi, just a quick one. Thanks for doing this. Always interesting. Responding to today's topic, what rights do the tenants have to be there during the repair? I have some tenants who like to surround me and my workmen as we work, and it's actually very intimidating to the
Okay, well,
landlord.
first of all, the tenant does have the right to be there, but the tenant under Civil Code Section 1954 has to allow access. Access is not just opening up the door and allowing the workman to come in. What if, for example, that while the workman's there, the tenant stands 10 feet away from the workman at all times, but puts music on to a level that's deafening? That's not allowing access to the unit, okay? So access to the unit means that they're freely allowing the workmen to do their work. If they're standing over them, okay, that is intimidating, and that would be considered by the law not allowing access to the unit, okay?
Do they have
So,
the right to ask questions and kind of semi-supervise the work?
okay, they have the right to ask questions, and you have the right to ignore. This is America. Anybody can talk, and also anybody can ignore. So you might say, I'm not answering any questions. We're just doing the work.
Okay, thank you.
Good question. Okay, let's move on to Margaret O'Brien. How are you today?
I have nice seeing you. Anyhow, I have two questions. On a 5-unit building under rent control in San Pedro, our insurance was canceled, and we are struggling to find an insurance. And I wonder if we find an insurance that does not cover, let's say, for fire, is that okay? I mean,
Well, you don't have to have insurance at all. I mean, it's what you decide. Now, if there's a loan on the property, the person who holds the loan, that bank, is going to demand that you have a proper insurance. So it's really a catch-22. This state is, and don't get me started, this state is so ugly in terms of protecting property rights. They should be stepping in with the insurance commission and making a deal with these insurance companies. Insurance companies are refusing to carry insurance policies on a lot of reasons, and it's all economic reasons. Look, if you can do business in a state, why wouldn't you want to do business in a state? And certainly the state of California. But the climate for insurance companies is so bad with all these crazy lawsuits that are filed against property owners for habitability claims, and where insurance companies are paying this off, and also because of and it's been stated that a lot of mismanagement with regard to forest lands, that these fires break out on a regular basis, that it's a climate here where the insurance companies don't want to do business. So you're just going to have to look around. I know there's the California Fair Plan, which does cover fire, and that's available, but the state really has to step up and create their own insurance company, which will have reasonable insurance for everybody here. Otherwise, you're just destroying all property rights in the state of California. Who's going to get property? Who's going to construct property if you can't maintain insurance? If I told you what the insurance was on the house that I'm sitting in now, everybody would just fall off their chairs. So it's really crazy.
We do own the property. There is no loan on it. So we could just skip it. But what if somebody breaks a leg for fun?
Yeah, you could skip it. I had another client just this week who's pretty savvy. He's a former dentist and he's been a client of mine for a long time. And he says he was considering just getting liability insurance so that if somebody sues him, and not get fire insurance, because how often do you think your place is going to go up in fire? And that's just a decision, an economic decision that you're going to have to make. Most people out there can't make that decision because there's a mortgage on the property. You're in a wonderful situation where you can. I would say about 10, 15 years ago, I had a fire that broke out into one of my units in West Hollywood. And that went on, the procedures, and it affected 3 of the 8, I think it's 8 or 9 units there. And it affected 3. We lost income. The insurance company for over a year paid income, paid the tenants' relocation expenses. And if I had to shoulder that myself, that really would have hurt us tremendously. So I think you have to do a little bit of soul searching whether you want to take a chance like that. At that point in time, if you're asking me, Margaret, I'd probably sell the building and find somebody else who wants it. And then, you know what, do an exchange and move out of California.
I can't move out of California.
Well, I'm not telling you to move out. I'm telling you to invest out, do a tax-free exchange and get some income property any place else.
Yeah, but we have huge taxes to pay, like 40%. I mean,
no, not if you're doing a tax-free exchange. I'm not a CPA, okay. But if you're doing a tax-free exchange, you can invest in others. In fact, there's a lot of ones out there. And again, I haven't done this myself, but there's a lot of REITs out there, real estate investment trust, where you're going to just invest in a group. You can do it as a tax-free exchange. And if you trust the group that you're going with, you basically are just sitting there and have nothing other than, watching your checks come in if you trust who you're going to use. Or get yourself a management company and find a place someplace else. But something has to give. You're sitting there, and God bless you, really considering not having fire insurance. This state is incredibly poor for any rights of property owners here. How can the state move on? They've got to solve this problem, and they've got to solve it quick. I mean, they're great with solving other problems that we don't have any need for, but this is one that really needs some help. Anyway,
where can we? I have one more question if you have the time.
Yes, darling.
Okay, we have also in San Pedro under rent control 2 houses on a lot, on a 1.5 size lot, and the people in the rear are moving out. And I just wonder, since the rear house is legal non-conforming, could we just tear it down and then have a single-family residence?
I would think you can. However, to get a building permit, they might not allow you to do that unless you're going to a building permit to demolish. They're not going to let you do it unless you're building another structure there. So this is not
But
my
it's
area of
it's
law.
legal non-conforming, it is sitting right on the property line, which is not something we did. We bought the building like 40 years ago.
I really can't answer that question.
Okay.
You'd have to deal with a land use attorney. And if you call my office, I can give you a referral to that. Okay.
Okay. Thank you very much.
Thank you. Okay, Kay, how are you today?
Could be better. Could be better. This is great timing though. So I actually had these tenants served with a eviction notice for owner occupancy. They're upset and actually just made a request for repairs about 15 minutes ago. They also, just for context, have also within a week of me actually purchasing the place, issued some harassment type of claims against me. So my question is, what's the timing that I need to take in terms of addressing this alleged air conditioning issue?
I would immediately check it out. That's all. Send an air conditioning guy over there. Do your 24-hour notice that an air conditioner guy is going to be there. You don't even have to show up yourself. Send your guy over. And if there's a problem, take care of it. Simple as that. Because you want to make sure that there's no, that's not connected to the fact that you are asking them to move because you want to move into your own place.
Right. Okay. And then just attached to that, it's severely under market value. Can I raise the rent while pursuing this owner occupancy or no?
If your property is subject to rent control, and it appears that it is, then you wouldn't be able to,
Yes.
be able to do a lawful rent increase.
But
again,
4%?
At this point in time, you've already served probably a 60-day notice to vacate. So it would be insane to be serving a rent increase. You're asking them to move. Why? That wouldn't make any sense.
Well, just for the time that they have to be here.
You'd have to serve a 30-day notice. You're already in the 60-day notice period.
Oh, okay.
It would never work. All right, we are going to move on to Michelle. Michelle, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
I have a problem. I have a single family house that is in Santa Barbara County, and my father had been he owned them and managed them for years, 25 years, 30 years. But I have a tenant that's moving out now. They've been there 25 years, and I have no idea if they have a security deposit or not. My father kept all his records like in his computer in his own little way that he would organize things that I've been looking and I can't find anything.
Is there a rental agreement that you can find?
I do have a rental agreement, but the rental agreement says that the rent is $700 when it's actually $900. So I guess
course, because the rent has been raised, but on that rental agreement, does it make any notation to a security deposit?
It does. It does say there's $1,000 deposit, but I think so many times my father has allowed his tenants.
Well, look, if you've got a rental agreement, and I'm sure the tenant has a copy of that rental agreement that says that a security deposit was taken for $1,000, you can't question that at this point. Say, well, my father didn't know what he was talking about. That's kind of silly. So
I should just go ahead, just give it to them.
You got to give it to them.
They've been there 25 years, and I know it's going to need like new flooring and all that other stuff. That's all.
But you can't hold them because that would be considered usual wear and tear, not unusual. So if they've been there that long, I'd probably give them back all their money. We're going to try to get through everybody here. So let's do, I see iPhone. iPhone, if you could unmute yourself.
Can you hear me?
I can.
Dennis, quick question regarding the access unit. What I noticed, what was not on that list was periodic inspections. Don't landlords have a duty to go in and periodically inspect the unit?
You think so, but if you read Civil Code Section 1954, you don't have that right. Now, what if you're saying that, hey, as normal maintenance, I need to check the smoke detector or maybe put a battery in, and it's kind of a wobbler situation. It's a gray area, but there is no periodic inspections under Civil Code Section 1954.
Well, let me ask you this. I just had an unconscionable water bill delivered to me, and I believe there's a leak. I
Well,
want to
then you
check
can
the
check
units.
for a leak. Sure. Then I would go in there to check to see if there's leaks.
But
Because
which
we have
option?
evidence, we have a belief that there's a leak because of my water bill. I'm going in there. Here's my notice.
I know, but which one of the options? That was not one of them.
To make necessary or agreed repairs. This is a repair that needs to be done. I need to stop this leak. It's bleeding me financially.
All right. Okay. Thank you.
All right. There we go. And we are at the end of the broadcast. Sorry that I couldn't get to everybody. That I did want to give everybody the news who waited. If anybody knows me, they know I'm not a big vacation fan. You know, I kind of just go to work, have my routines. But I got convinced by my wife to go for the next 2 Saturdays at least to the Mediterranean. I'm going to be on some cruise ship, and so we'll be floating someplace. So most people would think that I'm telling everybody not to tune in for the next 2 weeks, but I'm not telling you that. I am planning to do the show the next 2 weeks from the boat, from the cruise line, inside my cabin. And the boat has its own internet. And I'm bringing all my equipment with me. Triple monitors. I got really lightweight ones though. Triple monitors. I'll bring my camera and microphone, and we'll see if we can do it. Now, I am so crazy, ladies and gentlemen, that I didn't trust the boat to have proper internet. So on July 11th, just this week, a company by the name of Starlink came out with Starlink Mini, which is a way of getting internet from a satellite. And the thing is about the size of a piece of paper, and it's actually an antenna and a modem. So I'm going to have my own internet on the boat. So we'll see if we can make this work. I am going to have to get up at 2 a.m. in the morning to do this telecast, but I am prepared to do it. So tune in next week. But if I test it out and it's just not working, I'll leave a word on my website that the next 2 weeks will be a hiatus while Dennis is traipsing around, I don't know, Italy and Greece and God knows where I'm going to go. Anyway, thank you, everybody. Have a great weekend, and I do appreciate everybody coming out. Take care.